Augusta and Leslie.
All right, we are going to be talking about nature and value of assets. So full disclosure, I am filling in for April on this topic. So I'm using her slides and will do my best to stick to her material, but maybe a little hodgepodge of the two of us here. So we'll work this way. Joy, just want to get a clarification on what time this session is over. If you could put it in the chat. All right, so our topic now is how the nature and value of the assets contribute to the choice of planning tools. And so really the idea behind this category is when you meet with people, I always tell people that estate planning is really a blend of two things. It's the people and the things that you are worried about and the things that keep them up at night. And then it's also, now that we come up with this plan to deal with all the things that everybody's worried about, how do they take care of their loved ones if they're sick, if they die, things like that. What about all this stuff? Does the stuff work with that plan? And if all of their assets are retirement accounts that have beneficiary designations, then I can draft the best will in the world, but it doesn't matter because it's all going to be based on that beneficiary designation. If all their assets are joint, that will doesn't matter because everything's going to pass to the survivor. So it's really important to understand both sides of that equation. And so that's why this topic is so important. And so that's what we're going to be talking about now. So when we meet with clients, it's very important to get that good asset list from them. And it's not sufficient to just say, oh, we have bank accounts and $3 million. We want to know specifically, what kind of accounts are there? They have a Chase checking account in the husband's name, account 12345 with $20,000. They have a joint checking account at Citibank, and that one has $2,000. And they have a brokerage account in the wife's name at Merrill Lynch, and that one has $1 million. We want to know exactly what they have, where they have it. And the reason is that it gives us a roadmap of where to go from here. And so the more we understand, the more we can help the family when the first person dies. And of course, if when they meet with you today, they have a Merrill Lynch account, by the time they die, maybe they moved over to Morgan Stanley and they don't have that account anymore. It's possible, but at least we have a starting point. At least we know, okay, at one point in time, there was a brokerage account in the wife's name with $1 million. It was at Merrill Lynch. We can follow the paper trail to try and figure out where did that $1 million go. Maybe they spent it all, who knows? But at least we have an idea of what it is we're talking about. And also as we develop the plan, we know, are we dealing with a situation where somebody has $20 million? Are we dealing with a situation where they have $100,000? We're going to develop a very different plan based on how much money they have. We also are going to develop a different kind of plan on whether or not it's passing to children, if it's passing to young children. Right? We're likely not going to give them just outright everything to the 10-year-old. What if they have a special needs child? What if there's a special needs person involved? We're going to need special needs trust, supplemental needs trusts in there. We need to know all these pieces of the puzzle in order to properly develop the plan. So this is what I was talking about earlier was, for example, if everything they have are qualified IRAs, 401ks, Roth IRAs, for example, not going to pass through the will unless our beneficiary designation somehow ties it back in with the will. So for example, if we use disclaimer trusts as a popular planning tool, I know I use a lot of disclaimer trusts in my estate plans because of the flexibility it affords. We won't know what the tax laws are until someone dies. We won't know what those thresholds are for state and federal purposes until they die. So if I draft a plan that has a disclaimer trust and it turns out they do have a taxable estate when they die, they can fund a disclaimer trust and we can keep it out of the survivor's estate. So a lot of times we'll use certain assets to fund those trusts. We'll use the house, for example. It's a great tool to disclaim because they're not spending it at the supermarket. So if they have a house and it's titled jointly, passes to the survivor, I want to make sure I include language in my will that says that even if the person has inherited jointly held assets that pass by operation of law, that those assets also can be disclaimed and fall into the disclaimer trust. So that way I know I can direct where that goes. If I have retirement accounts, I might leave it all to the spouse, but put a designation that says, but if my spouse disclaims, then this retirement account goes into the disclaimer trust. Why would I want to put a retirement account in the disclaimer trust? Because I also have language that says that the required minimum distributions flow out of the disclaimer trust and pass to the spouse. So, which is the exact same as if it was in that spouse's pocket. They're not touching the underlying value of that retirement account. And many clients have a lot of money tied up in their investment accounts, in their retirement accounts, rather. So because these retirement accounts could be so big, which would cause their taxable estate to be big and maybe go over the thresholds for tax, by funding the disclaimer trust with these retirement accounts, instead, we've taken this large asset. So they have $500,000 401k from work that's now in my disclaimer trust. They're still getting the RMDs, the surviving spouse still getting the RMDs out of it, but they were never going to touch that underlying $500,000. They weren't spending that at the supermarket. They weren't using it to keep the lights on anyway. So whether it's in their individual name or whether it's in the trust doesn't affect their quality of life. It doesn't affect their day-to-day living. It doesn't matter if their trustee turns out not to be the yes man we thought that person was, because we're not relying on distributions from that. So it's important to know what kind of things we're dealing with so we know how we're developing our plan. Okay, so when we're talking about real estate, it's also important to know the laws of your state. So every state has different laws. I know this is a national discussion right now. So I am in New York. I'm also licensed in Connecticut. So we don't really get into the whole homestead thing, like, for example, Florida does. So there's very different rules depending on where you are. So you want to know what your jurisdiction provides, because that might decide whether or not you want to put the house into the trust. So for example, in New York, we would fund a disclaimer trust with the house. In Florida, my colleagues down there say, no, we wouldn't do that because that would screw up all the homestead issues. So you want to really don't go rogue. Ask questions of your colleagues that are licensed in the states where you're dealing with things. If you are, for example, creating a revocable trust, and maybe you're creating the revocable trust because somebody has real estate in another jurisdiction. So for example, I have a client coming in to sign next week. They have a house in Vermont in addition to their house in New York. So I found a Vermont attorney, someone that had worked with another one of my colleagues, and she prepared all of the Vermont paperwork to transfer this house into 50% into the wife's revocable trust and 50% into the husband's revocable trust. So now when they pass away, I don't have to go into court in Vermont in addition to New York in order to probate the will, because they're not going to die owning something in their individual name in another state. Instead, they're going to die with a trust owning that property in another state. So I avoid ancillary probate in that other jurisdiction. Now, I am not licensed in Vermont. I have no idea what is needed to transfer property in Vermont. Could I figure it out? Maybe. Could I go online, Google it, ChatGPT, all those things and try and figure it out? Perhaps. But is that really the best way to do it? Is that ethically the right way to do it? No. So the right way to do it is you find somebody in that state who can do it. You partner up with them, and you either have a separate engagement letter between that attorney and the client, or perhaps you and that person, because you're hiring them as the consultant and you pass the costs through to the client. In this case, the woman who's doing it for me in Vermont, she didn't even have us sign an engagement letter for it. So it'll depend on who you're using. We have another client who just signed last week. They have a place out in California. I found a company online that does all sorts of property transfers for people out west. They do California and Nevada and Arizona and all those states out there. And I had to send them information, and I have to pay them, and then again, I'll pass the cost on to the client. So it's important that you get this information from clients. It's important to get those deeds. It's important to see how things are titled when dealing with real estate, because a lot of times clients will come in and tell you, oh yeah, we own the house jointly. And then it turns out, I just had this the other day with someone, the wife owns the property. They don't own it together. They of course said it was joint, and when my paralegal pulled up the deed to transfer it to the house, just in the name of the wife. So then my paralegal was saying, well, what should I do? Should I transfer it now into both of their trusts, which was our original plan when we thought it was owned jointly by them, or should I just transfer it into the wife's trust? So I said, no. I said they intentionally had it in the wife's name because a lot of other business investments are in the husband's name. I think they had originally done it to balance assets out. So we said, no, we're going to keep it in the wife's name. We'll just put it into the wife's trust. But it's a perfect example of a client telling you one thing and the reality is it's something else. When you are dealing with other kinds of assets like brokerage accounts or bank accounts, there's a couple of different ways to do it. So one option is you just retitle the account into the name of the trust, for example. So this is if they were funding a revocable trust. And this is one of the things with a revocable trust is that if you are creating it to avoid probate, you need to make sure the assets are retitled in the name of that trust. So most institutions will not just slap on revocable trust after the name of John Doe and Jane Doe, and they will make them open a new account. Even though it's still using their social security number, even though nothing has really changed other than just adding the words revocable trust, in their internal system, they have trust accounts and they have individual accounts, and the two are not the same. And so therefore, they need to open this up as an entirely new account. Well, that's not a problem unless, of course, you have auto pay set up, you have direct deposit set up, you have all these things set up with your checking account, you have Social Security being deposited into it, for example. Changing all of these actions that happen on a monthly basis can be very complicated and can really be a headache. Certain things, okay, not a big deal. You open up a new account, you have to reset up how to pay the electric bill, and maybe it's not such a big deal. But having Social Security hit a different account, that could be a real headache. So another way to do it is to name the beneficiary on the account as your revocable trust. So this way, you can leave your checking account alone. You can leave your brokerage account alone. You don't have to change any of that. You just slap a TOD, transfer on death, or a POD, pay on death, onto that account. Here's the wrinkle. Some institutions will not allow you to name a trust as the beneficiary of an account. They will only let you name an individual. So it's really going to depend institution by institution. It is not a one size fits all. And it's also going to depend on the person at that institution. So you might have a wonderful person who works at your local Citibank branch, but another client walks in the door and they're in a different part of town or a different city, and that person doesn't have a great person at Citibank to help them. And that person, when they go in, it makes it a nightmare to do it. So there's no one size fits all where you can say, oh, Citibank always is a breeze, it's easy. We actually had this problem with Wells Fargo where a client was helping her father change titles and adding beneficiaries and things to avoid probate, and was working with Wells Fargo, was uploading powers of attorney. No problem, easy peasy, going great. They took care of a bunch of accounts, and then they got to the last account at Wells Fargo, which they went in on a different day to do for whatever reason. I think they forgot about it or whatever. Different person handling it. Nightmare, an absolute nightmare. They wouldn't even, down to the notary. My notary stamp, I cross off the year and I handwrite it in. Never had a problem with it. This one person at Wells Fargo said they wouldn't accept it because my stamp didn't have the actual date. It was handwritten in the date. I said, I've never, so that's not a thing. That's not a problem here. But for that person who was handling it, it was a problem. And so here they had smooth sailing, pleasure to work with. They were thrilled with the customer service, and then suddenly they hit this roadblock. So that can be a problem and a headache. So it's good for clients to know they have choices, that they can either retitle it completely or they can add the designation of the beneficiary, and they should work with their advisors and they should see what kind of beneficiary designations they've got going on. It's also a good time to perhaps consolidate assets. So if they have several brokerage accounts or several checking accounts, there may have been a reason at a point in time for having multiple checking accounts. There was the one that was near their office and the one that was near their home. Uh, Now that they're retired and not working, do they really need to have that account that was near their office? Can they close that and add that money into the account that's near their house? So it's a time to not just automatically blanket say, let's consolidate, but it's a good time to take a look and say, okay, let's do a well baby checkup here. Let's look at what we have, and then we can make an intelligent decision, an educated decision about what's right for me. No, I don't need three checking accounts. I'm fine with just one checking account, and I'm fine with using, this one because it's down the street from my house and I like the people. I get good customer service there. Okay, great. So we consolidate it. If they have personal property, vehicles, boats, artwork, just the sofa in their living room, if they're creating a revocable trust, for example, we don't want to have to probate the will just because they have artwork or they have a sofa or they have dishes in their cabinet. So we'll oftentimes do a deed of gift in order to transfer their tangible personal property into the trust. And the way I like to draft it is it covers everything they have up to that point and anything future that they acquire that's in their home, for example, or in their homes if they have multiple homes. So you want to make your language in that deed of gift flexible enough so they don't have to keep running in to do a new deed of gift every time they change their china pattern. It's going to work for most of their tangible personal property. It's not going to work with things like your car or your boat. Those things would have to actually be retitled. And depending on your local Department of Motor Vehicles, it may be that they don't allow a car to be owned by a trust. I don't know what the rules are of all 50 states. So you have to just double check with with every jurisdiction you're dealing with, what are the rules? Can you add a beneficiary? Can you retitle it? What are the rules? And you want to, again, get those copies of the ownership to find out. Now, also, some jurisdictions have special rules for motor vehicles. So, for example, here in New York, if the car is worth less than 25,000, we have special rules and it automatically passes to the surviving spouse. For example, I don't have to probate necessarily to transfer it. I even have some special rules if it's going to children. Every jurisdiction's got their own little thing going on. So you want to make sure you're up to date with what your jurisdiction provides. So that way, what do I have to do? And am I going to have to go through probate just for the car? And maybe you do, but maybe if that's where you're at and that's what you have to do because you can't transfer it to a trust and you don't have a special rule about transferring it to a spouse or a child or something, then maybe you can do a small estate administration if your state has something like that. I know New York does. We have a special proceeding for estates that are worth less than 50,000. So every now and then we'll get one because we've got a car, for example, that we have to deal with. And when the car is usually less than $50,000, it's not a problem. We'll do this proceeding. There's a $1 filing fee for it. It's just a much simpler, streamlined proceeding. If we have a business, then we need to retitle that as well. So we need to do assignment and assumption agreements. With that, we want to make sure we're assigning the interest in that closely held business into our trust, for example. And we want to make sure that they are agreeing to assume the responsibilities of the governing agreement. So if it's an LLC, we've got an operating agreement. If we have a partnership, we have our partnership agreement. If we have a corporation, we have our shareholders agreement or bylaws. There's always some agreement that's governing things. It's also important to see what those agreements say. A lot of times when people created these agreements, they might have been boilerplate stock ones that came with the minute book. They might have been something that was drafted because they were focused on some business issue that was really essential to the creation of the entity, and that nobody really paid much attention to the clauses that were, in the second half of the agreement that dealt with transfers. They might not allow transfers to family members intentionally or by accident. Maybe they intentionally said, I don't want you to be able to transfer it to your spouse because I don't want to be partners with your spouse. I want to be partners with you, but I don't want to be partners with your wife or your husband. I want to be partners only with you. So if you die or if you get sick or you just decide to retire or whatever it is, you can't transfer your interest to a spouse. You have to sell it back to the company. Or maybe it doesn't say anything about being able to transfer it into a trust. Maybe it only says outright. You can give it to a spouse, you can give it to your kids, period, end of sentence. Doesn't say anything about, well, what if I don't want to give it to my 10-year-old? I want to put it in trust for my 10-year-old until they're 30 or 40 or whatever it is. So we may need to amend those agreements as part of the estate planning meeting with the client. And a lot of times I get a lot of pushback here on getting these agreements, especially if they're involved in a lot of investments. It's a real fight sometimes. And the example I like to give is that I had a client who they became our client after the wife died. The kids were in their early 20s. The husband survived. She was in several businesses with her siblings. When I finally got copies of the agreements after she had died and we were reviewing them, the will said everything to my husband. But these operating agreements said they cannot pass to a spouse. They can only pass to blood relatives, which meant that the husband, who thought he was going to be living off of the income stream that came off of these businesses, the same way he and his wife had lived during her lifetime, suddenly this whole income stream is going to their children, to their 20-year-olds or their 20-something-year-olds. And it was not going to him. And that was a really rude awakening for him because he needed this money to keep the lights on and food on the table. And it was not to be able to pass to him. If I had represented that client during her lifetime, then if they had given me copies of their agreements, we could have had a conversation about this. We could have talked to the siblings and we could have said, we understand you don't want to be partners with the husband. We get that. But what about, would you consider a trust for the husband where one of the trustees is maybe one of the other siblings? So that way it's still a sibling sitting at the table, but the husband can get that income stream from the interest and not be sitting in the dark while he's looking at his empty plate of food because he's not getting the income stream. In this case, I have a feeling the family would have agreed to that because this was a family that really does get along and takes care of each other. And if they had been presented with this alternative that might have resolved the issue of, we don't want to be partners with a spouse, but we also don't want your spouse to starve, here's a nice hybrid solution, we might have been able to amend that agreement and come up with something. But as a result, we didn't have that option. If we have qualified assets, we did talk about that. So I'm not going to talk about it again. It's important with the titling of the assets to make sure you understand who is responsible. So one of the documents that we prepare is a document that talks about how to retitle assets. It's called Funding the Trust or something like that. And it goes through all these different kinds of assets that you might have, many of which the client might not have at this part in life, but maybe, who knows, one day they might get an oil and gas interest, who knows. Then it talks about what you do with each one of these assets. So if you have real estate, you need a deed. If you have a checking account, you need to go to the bank, et cetera. And they have to sign this funding agreement to make sure that we know that they know what they're supposed to do. Then we always have a conversation with who's going to do this? Who's going to make sure that the assets actually do get retitled? It's very important to know, is the client going to be able to handle that, or do they need help? Do they need us to hold their hand? Do we need to be on the phone with them at their financial institution? Do we need to take care of preparing the assignments, or is the company going to send us their form of assignment to use? So sometimes I draft using our form for a client who's coming in next week, the same one who are in Vermont. They have some business interests. These companies they're involved with sent us the form to use that we had to go through and customize. So I see a question came in. Corporations are by law to be run by the board of directors and officers of the corporation. How are these requirements reconciled with the transfer of the business to a trust under the direction of a trustee? So depending on if the shareholders agreement allows for a transfer to the trust, so that way a trust can be a shareholder. Just because you're a shareholder doesn't mean you are also a director and a member of the board of directors, so that you can be a shareholder and not necessarily a director. A trust, the trustee of a trust could be a director. So depending on what the governing agreement says is going to also affect how this works. But remember, there's that difference between governance and ownership. So that's going to be a key distinction there. Not unlike with an LLC, for example, where the managers are running the LLC, and we have our members who have the interest in the, who have the ownership interests. Okay, so we are right on time. So 2 o'clock, and now you're still stuck with me. We're moving on to complexity of distributions. And again, I'm covering this time for Craig. So now I'm wearing my Craig hat. And okay, let's dive on into this one. So I do want to point out that Craig's materials are Arizona-based materials. And as I said earlier, I'm New York and Connecticut. So he refers to a lot of statutes, both on his slides and in his materials. So I do urge you to look at his materials for a little deeper dive into the statutes that he's referring to, especially if you do live in Arizona. It'll be very helpful. And I'm going to talk more generically about it, and maybe with an eye towards New York and Connecticut, since that's what I know. I also did review his materials, so we'll see how it all goes. So just we'll wing it a little bit. All right. So the key is that the wills and the trusts, so either document is going to say what happens with the assets that are being held. So if the assets are being held in the estate by the executor, or if the assets are being held in trust by the trustee. So our documents are first going to say, they tell us a story. They're going to tell us who is in charge. Who's the executor if it's a will, who's the trustee if it's a trust. They're also going to tell us what happens with everything. So first off, you got to collect the assets. So either way, you have to collect the assets. The next step is going to be, okay, now I've got everything. I've got it in one account, one estate account, one trust account, multiple estate account, multiple trust accounts. It's no requirement. It's whatever you're comfortable with. You don't have to keep the accounts at the same institution where the person had it. So if they died having a Morgan Stanley brokerage account, you can open a Merrill Lynch brokerage account for the estate or the trust. You can move it wherever you have your relationships, or you can leave it with the same advisor that helped that person during their lifetime. So depending on the relationships, depending on oftentimes that person will reach out and they will try and work with you and maybe get to know you. And you might say, oh, they're really doing a nice job and they are really doing their best to create a relationship. So I'm going to leave the money where it is. So that being said, we collect it, we've opened our accounts, we pay our bills next, we file our income taxes, we maybe have to file estate tax returns, we take care of all of that. And now that we are done, we've got all of our obligations taken care of, next step come distributions. And that's what happens when someone dies. But how do we get to that point? So we get to that point by thinking about, well, who are we benefiting? Who are we taking care of? Are we taking care of someone who's elderly? Are we taking care of someone with special needs? Are we taking care of somebody who's a minor? Okay, so are we worried about estate taxes? All of these factors are going to come into our decision when we're creating the documents, when we're creating our trust or our will, and we're designing our plan. And so as we're thinking about these things, we're going to develop a plan that is going to be tax sensitive, that is going to be sensitive to the other issues that I just mentioned. And so Craig has, for his, he calls it 6 courses: the description challenges, minor beneficiaries, predeceased beneficiaries, beneficiary money management challenges, binding distribution proposals, fiduciary protection, receipts, releases on distributions. So sometimes our documents just say, they're outright, I give it to my spouse, or I give something very specific to someone. So in our example here, I leave my collection of Crosby, Still, Nash and Young CDs to my cousin. It can get very specific. The problem with specific bequests is that what if they don't have those CDs anymore when they die? Maybe they donated them because they don't use CDs anymore. Everything's all digital and they just use their iPhone or whatever. So you have to be careful that when you are doing these very specific bequests, that you have provisions that contemplate the idea that these things could lapse because you don't have it anymore. The other issue is that by naming it in there, it's going to cause somebody to be looking for it. And if they don't know that you donated it, or they don't know you threw it out, or they don't know you just sort of lost it over time, you lent it to somebody 30 years ago and you never got it back and you forgot to change your will or whatever, someone's going to be looking for that. And maybe it's not a CD collection. Maybe it's, my diamond ring, something with a lot more value to it. And so that can cause accusations of theft. Maybe if there's multiple children, you stole the ring, dad wanted me to have it, it's not there anymore, you must have stolen it, and all of those things. And so you got to be careful with those things and think about, am I going to be causing problems down the road? Is there a risk that I'm going to be causing a problem where I don't need one? The other issue is that even if I'm not doing specific items, and I'm just doing a specific dollar amount. So in our next example, he's leaving $5,000 to his friend. Okay, well, we want to contemplate what happens to Joe in our example here. What if Joe dies? Should it go down to Joe's children? If Joe has children, should it just go to Joe? So we want to be asking those questions when we're meeting with the client to identify what happens if that person isn't around. Is it, I really just want to give this to Joe. I'm not really concerned about his kids. If he's around, fabulous. He gets it. It's a windfall to Joe. But if he dies before me, his kids don't get it. I guess I understand that if I gave it to him and he was alive, then one day he could turn around and give that to his kids. I get that, but he's got to be alive to get it. Otherwise, forget it. He's out of luck. That's okay. But you have to have the conversation with the client because otherwise you don't know what they want to do. The other problem with doing specific dollar amounts is that people, when they meet with you, they have, if you get good asset information, you can be sure to make sure that those bequests work. So it's very important. Again, we talked earlier about getting that specific asset information from them. Don't just get, I have $3 million in cash and securities. Get that breakdown because we want to know that this plan works. Because what if they're giving lots of money to different people or to relatives or whatever it is, or to charities? Will this plan work? What if their assets are tied up in retirement accounts? You're not going to be able to give $5,000 to Joe because it's in a retirement account and that's not going to be governed by your will and this plan won't work. The other problem is, what if they don't have that money left? You could end up where all these pre-residuary bequests end up spending the whole estate and then the residuary beneficiaries don't really inherit. We actually had this problem once where I had met with a client. We got all the asset information, great asset information. He had very specific bequests. He wanted to fund trusts for his grandchildren and for one of his daughters that had some special needs, and made sure that there were sufficient assets that would be able to fund these bequests. And there was plenty left over and no problem. And then the other daughter was going to inherit everything else. Well, as it turned out, he had a gambling problem that nobody knew about. And when he passed away, he had hundreds of thousands of dollars of gambling debts that nobody knew about, that he had never mentioned to anyone. People knew he occasionally went, to the casinos and he went with friends. It was like a social, event, like instead of going to the movies or bowling, they went to the casinos and they gambled or they saw a show and they had a nice dinner. And it was just a nice out, weekend away or whatever. They were retired and nothing to even think twice about. But apparently, in addition to those little jaunts, he was constantly at casinos. Nobody knew it. And just gotten himself into serious gambling debts. And so I had my poor paralegal, she had like pit bosses calling her saying, when are we getting paid? When is this money coming? She thought for sure someone was going to show up with a baseball bat and break her knees one day because the estate hadn't paid out on these debts. Well, by the time we were done with all these gambling debts and took care of everything, plus all the regular, debts and issues and things that we knew about, suddenly that ate up all of our pre-residuary bequests, and the daughter got very, very little as compared to all the grandchildren and her sister because we didn't know about these debts. Even though we had really good financial information, we were missing a piece of the pie because the client hadn't been honest with us. If instead we had drafted that will to do percentages, then when it turned out our pot was much smaller, the other daughter would have still gotten an inheritance because those trusts wouldn't have been funded as much because everybody would have just gotten a percentage. So what I try and encourage my clients to do now, because of that event that happened all those years ago, is I say, okay, you want to give $500,000 to a trust for your grandson. Okay, if we look at all your assets today, what percentage of your estate is that 500,000? Is it 1% of your estate? Is it 10% of your estate? Is it 50% of your estate? What is it? What does that $500,000 represent? And then once we have our percentage based on today's numbers, we say, okay, we're going to draft a document, whether it's a will or a trust, that's going to say, I give 10% of my estate to the trust for my grandson, because that would equal this 500,000, assuming the assets stay the same. And then we say, all right, well, what if your assets increase over time? You have a great investment advisor, they invest it really well, you're not a spendthrift, and your assets balloon in value. And now your assets are greater, which means that the 10% of your estate isn't going to be 500,000. Now the 10% of your estate is 600,000. Are you okay with that? Are you comfortable with that much money going into this trust for your grandson? And maybe the answer is no. Maybe the answer is no. I want it to be 500,000. I'm not looking for it to be more than that. I think enough's enough, and I want the rest to go to my kids. Okay, fine. I can put a cap. I can draft it to say I want 10% of my estate, but no more than 500,000 to go into this trust for my grandson. So that way, even if the estate gets bigger, I am not unintentionally giving this grandson a windfall and lots of more money. I can also deal with it on the flip side. I want to talk to the client. Okay, well, what if your estate shrinks in value? What if now 10% of your estate is $400,000? Are you okay with your grandson getting less? Are you okay with this trust only getting 400,000 instead of the 500,000 because you don't have as big of a pot now? And the answer usually I find is yes. I'm good with that. That's why we're doing it as percentages, because I don't want my other relatives not to inherit. But sometimes they really have a clear no, 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 even if it means my daughter would get less or maybe nothing at all. It's very important to me that my grandson get this 500,000. I don't usually see that, but once, if you don't ask, Murphy's Law, right? So we always want to ask, we always want to find out. So you really want to do it. And you also want to make sure that if, let's say, they want to leave the house to my daughter, I want to give my house to my daughter. So we go back to that client that told me they owned their house jointly. And when we looked at the deed, it turned out the wife owned it, right? What if I had they came to me and they said, oh, the husband owns it. And they swore up and down on a stack of Bibles that the husband owned the house. So I did a bequest in his will or in his revocable trust that said he leaves the house to his son. Well, it turns out he doesn't own the house. The wife owns the house. So that bequest is wasn't worth the paper I wrote it on. So if you're going to be doing a specific bequest of real estate, you want to get that deed. You want to make sure, do they actually own that property? What's going on with it? And does this work? And what if they sell it and they buy something else? Then is it any property or is it just that specific property? I only want that Vermont house that's on, 123 Main Street to go, or is it any Vermont house that I have, because maybe I downsize or maybe I upsize, and so who knows? But you got to ask the questions. If you don't ask the questions, you're not going to draft it right. So asking lots and lots of questions, creating a safe space for the client to be in so they give you honest answers is so key to drafting documents that really work and accomplish their objectives. So with minor beneficiaries, more often than not, we don't want to leave it outright to our minor beneficiaries. We want to make sure that the documents say it goes in trust for our minor beneficiaries. We don't want to just rely on the minor's clause. And some clients say, no, I'm okay. It's not enough money to worry about. I don't need the cost and expense of a trust. And I'm okay with it just being under a minor's clause, and that somebody can hold the money for their behalf, maybe a guardian, maybe a parent, and they'll take care of it. And that's okay. But most of the time, especially with the dollars that are at stake, they don't want that structure. They want it in some kind of trust. They want it to go longer. So you want to find out, okay, what is it that you want to do? What age is the right age for this thing to end? Um, what is the money used for in the trust? Some people are very specific and they only want it to be used for education, for example, or to buy a house. I had one client who was very insistent it had to be used to help her grandchildren buy houses, buy, whether it was a house, an apartment, some kind of residence. That was like a bee in her bonnet. She just wanted to know she was responsible for putting a roof over their head. I personally like to draft things very flexibly. My feeling is if I draft a trust that says it can only be used for education, definitely that kid is getting a full ride and a scholarship somewhere and is never going to be able to touch a penny in that trust because they don't need the money for education because they got a free ride somewhere. I had a friend who only wanted to grow up and be a plumber. And I always think, like, what if his grandparents had set up a trust for him and said that he, could only use it for higher education, and he ended up, going into the trades. He is a successful plumber. He does commercial plumbing for restaurants, does very well, lives in a beautiful house, very comfortable. But that money would still be sitting there because he didn't take the same kind of educational path that a lot of his peers did because he went into a blue collar profession and took a different route in his life. A lot of times the clients are worried about their relatives becoming couch potatoes and just trust fund babies lying on the sofa eating bonbons all day watching TV. And that's what they're trying to avoid. So that's where this must only be used for education or only to buy a house or something very extreme and big like that are coming from, is from those fears. So by drafting with more flexibility and saying it can be used for any reason, then it enables that kid to get his plumbing business off the ground. Or when they graduate, when they have their free ride to college to buy a car so they could go drive into town for their job, their internship that they got, or to be able to come home on vacations. You can use it for other things that supplement all the good things that that kid is doing. If you pick the right person, they're going to tighten those purse strings and they're not going to give them the money to lie on the sofa and eat bonbons all day. They're going to say, I'm sorry, that's not what this trust is for. I have a trust where the guy, the beneficiary, likes to eat gourmet chocolates. And he wants to, and so he was, the trust was paying for groceries at the supermarket for him. And then once the trustee got the itemized bill from the supermarket and saw the things that he was having his aide buy for him at the supermarket and saw there were a lot of these fancy chocolates on there and other things like that, the trustee said, this is for needs, not wants. You want to buy fancy chocolates, go use your own money for that. The trust is not funding your fancy chocolate habit. That's not what this money is for. This money is for necessities. This money is for the basics and emergencies, and not for fancy chocolates. So it's important for the trustees to be asking questions. It's important to pick the right trustee who is going to ask the questions. And so that way, when the trustee is making distributions, the trustee knows what they're doing it for. You can also include holdback clauses so that way if the beneficiary gets into trouble, is having problems with drugs or alcohol, or got into creditor problems, or is getting divorced, that the trustee can say, okay, this trust was supposed to end at age 35, but you're a hot mess right now. So I'm not giving you this money at 35. I am turning that knob and I am stopping the flow of money. And when the coast is clear and you get your life back together, then I will give you your money. So some clients like those kind of provisions. Other clients don't. They feel it's too much control from beyond the grave. So I like to have that conversation with clients to let them know it's a choice. I often liken all of these different options as a buffet. And I say, all right, you got to go up to the buffet and do your lap around it first, because nobody goes up to a buffet and takes the first thing they see. You got to do your lap around it. So you got to tell them, okay, these are all the different choices you have. You can do something that ends at a certain age. You can do something that's a term of years. You could do something that's for their lifetime. You can do a holdback clause. You can give them a percentage of the assets. You can have an allowance. You can have mandatory income. You can have discretionary income. You can have all these different kinds of things. What looks yummy to you? And so you sort of take them on that tour around the buffet, and then you say, okay, what looks yummy to you might not look yummy to the person sitting next to you or the next client to walk in the door, because everything's yummy on a buffet. It's just what you feel like, what you're in the mood for that day, and what makes sense for you and where you're at now. So you've got to really walk them through all these things. And again, this slide talks about what we talked about earlier about what happens if somebody predeceases. Do you want it to go down to that person's kids, or should it just be, no, I wanted it to go to Joe Schmo and that was it? This talks about the holdback clause that we talked about. You want to see what the rules are in your state with when you have to shut down a trust, when you make distributions out of a trust. Do you have to give notice? Do you need court approval, for example, if it's a testamentary trust? So, for example, in Connecticut, when we terminate a testamentary trust, we need court approval in order to do that, and you need to petition the court in order to shut it down. In New York, we don't need that. So every state has different rules, and it's really important to know what the rules are for your state. It's also very important that when it comes time to making these distributions and it's time to shut down a trust, for example, or even an estate, that you don't distribute it without protecting your fiduciary. So as the attorney, you likely are representing the fiduciary. Sometimes we represent beneficiaries, but most of the time we're representing the fiduciary. We want to protect them. We don't want one of these beneficiaries coming back years later and suing our fiduciary that we represented and saying, you did a lousy job. I didn't get what I was supposed to get. So we prepare something called a receipt release, refunding, and indemnification agreement. I include an indemnification clause in it as well. And sometimes they're one-pagers, and other times there are several pages. It sort of depends on the situation. It depends on your cast of characters, and depends on the situation and what you need, and sort of why are we shutting down because the trust really has come to an end? Are we shutting down early because there's really no reason to keep this thing going anymore? I just had that go out the other day. A woman who's well into her 80s, has adult children. She said, there's no reason for this trust to keep going. I can shut it down and distribute out the rest of the assets that are in this trust. Actually, it goes into other trusts for the children and their families. It splits down into different trusts for them. She said there's no reason to keep that original trust in place anymore based on what's going on in everybody's lives. There was a time and a reason for it, but that ship has sailed. There was an underlying asset where that just sold its commercial real property, and that happened last year. So now that whole thing is done, it was a good time to shut it down. So we're just doing one-pagers in that one because everybody's on the same page. This family all gets along, which is very unusual, I must say. And so we can cover all the basics, hit all the high spots. We have some attachments. We're attaching copies of brokerage statements and information about a partnership that it owns. So that way we don't have to get into pages and pages of the actual agreement, because for that family, something like that will work. For other families where they fight about everything, or we're worried about a possible fight in the future, we want to make sure that agreement covers everything and covers the history of it, covers everything that's been going on in it, and really gets into the weeds as to what's going on with the transactions and the why. Why are we able to do this? Is it because it's time to shut it down based on an age, because it's been so many years, because we've hit a certain date on the calendar? Whatever it is, that's why we're shutting it down. So we want to make sure that our document says, okay, the beneficiary has received it. That's our receipt part. Releases our fiduciary, whether it's the executor or the trustee, that they release, refund, that if we over distributed and maybe some other debt comes up, that they agree to refund to us an amount that we may need. We actually just had this happen where there was an estate. They didn't have all the correct information. And when they prepared the receipt and release, the numbers were a little bit off. And as it turned out, there was another bill that came up. Oh, no, it was the commissions. I'm sorry. The commissions hadn't been paid. But because there was a problem with the calculations, because they actually didn't have the final statements and they were sort of estimating on some numbers, they were off, and there wasn't enough money in order to pay I believe it was the trustee, her commissions. So that was a pretty big deal to her, the trustee who was the client. Unfortunately, the person who drafted the agreement did not include a refunding clause. So now we have a situation where this is a family that does not play nicely in the sandbox. There is no refunding clause, and we need to get money back in order to pay the trustee the commissions. So how are we going to do that? Well, can we ask the beneficiaries, maybe out of the niceness and the kindness of their hearts, they will, even though there is not a actual refunding clause in the agreement, they will still say, this is the right thing to do. Even though I hate this person, this is still the right thing to do, and I will do it. Will there have to be litigation? Will the firm just have to eat the difference? There's a lot of unknown and a lot of question marks, but there's a lot of things that, had a refunding paragraph or paragraphs been included in the agreement, wouldn't be having any of these conversations that they're having right now on this particular matter. So we'll see how that shakes up. Maybe the next time I present, we'll have an answer on that one. Then we have the indemnifications. We want to make sure that our trustee or executor is indemnified, and nobody's going to come back and say you were, did a rotten job, that this way they're protected. And years ago, I had an estate. There was a trust also with it, and there were 4 children. One of them died, predeceased the dad, and he had 2 children. So there we have 3 siblings, and then the other deceased brother, he has 2 children who took his share because it was per stropies. I had bad vibes with this niece and nephew. I just saw the nephew as a troublemaker. And so it came time to distribute a big chunk of the estate. We were doing a partial distribution because we just gotten all this insurance money. We knew we were selling the house. And so the executor trustee wanted to make a big distribution. I said, that's fine. I said, but we need a receipt release agreement before we give anybody a check. No, I don't need it. It's fine. It's family. Everybody's going to fund. We don't need that expense. I said, I'm telling you, this kid is a problem. You need an agreement. And we fought and fought and fought about this. And I wore her down, and she's fine. I'm tired of arguing with you, Leslie. Just draft the agreement. I said, great. Thank you. Drafted the agreement. And one practice that we have and that many people have, and I see that Craig has as well, is that before you send out that check, you get that agreement signed. So you reassure them, and we get this question all the time. It says I received the money, but I haven't actually received it yet. How do I know I'm going to get my check? I said, well, because you have all this correspondence from us, the attorneys. You have all these documents that are signed to say you're getting your thing. If we decide to stiff you and not give your check, you have letters saying that we are going to give you your check, and you can take us to court and say that we stiffed you on it. I said, you'll get your money. We're not in the business of holding back the money. And usually that's enough to placate them, and they're comfortable, and they take their money and they're good. And they'll sign. Anyway, in this case, back to our client, we send out the agreements, everybody signs, we send out their checks, great. 6 months later, we get in touch by the nephew's attorney. He's lawyered up. The attorney reaches out to us and says, there's all these problems with the estate and the trust and all these issues, and you owe my client all this money and a whole to do. So I send a copy of the agreement to his attorney. I said, are you aware that your client signed this agreement and that he's already released the fiduciary with regard to everything up until this point? So all the stuff you're yelling and screaming about is moot because he's already released my client. He's already indemnified my client. He's already said he's gotten everything he's entitled to, and we're done. And so his attorney looked at it and said, nope, had no idea he did this. And yeah, you're right. And ignore all my emails and we're good. And as it turned out, this kid continued to be a problem. So for everything from that point until we finally shut down, which we are this close to doing, this has been going on for like 10 years. But he's been a problem every step of the way. And so much of the estate has been eaten up by problems that he creates. And so to this day, the executor, she says, thank you for making me sign that agreement, because you really saved my tush on that one, because we really were able to, protect everything that had gone on and make sure that this way he wasn't going to be able to come after me for everything I had done up until that point. And that's why we do those agreements. So it's not enough to say, well, the will says I'm supposed to get this and you got this. If there's a problem beneficiary, there's going to be a problem. And you just want to get out ahead of it. And you want to make sure that everybody says you're okay. So we are at 2:30. We're going to take a break now for 15 minutes, and then you're stuck with me again when we get back from the break for my third topic, which is actually my topic. And although I actually am covering from someone, but you get my materials this time. And Joy, anything else you need to add before they go on break? Hello, everybody. Thanks, Joy. Okay, so you've got me, I think, until 3:15. So we will keep plugging along. So we've been talking a lot about trusts and wills and that all these provisions about how to draft them and what should they say, and the trusts should we have specific dollars amounts or percentages, or should we have it passed to the descendants of somebody if they die first? Should it go in trust for somebody? All these things that we've been talking about. And then, so we've been talking sort of interchangeably about wills and trusts. And the reality is both of them are good and accomplish what you need to do. And both of them have some issues associated with them. Nothing is 100%, and there is no slam dunk, and there is no one size fits all. And I should have mentioned earlier, my information is in this slide, and I am happy to answer any questions that you think of after our sessions today. And I am happy to answer phone calls or emails or whatever. So feel free to reach out. And in addition to this PowerPoint, there's also more detailed information in the materials that you get from today. So I encourage you to take a deeper dive. Again, it's written with an eye towards New York law, but a lot of this stuff really pertains across the board, regardless of where you live. So with regard to a revocable trust, which is where we're going to start our conversation on this topic, it can be terminated or amended by the grantor during the grantor's lifetime. Sometimes the grantor is called the settlor. It really depends on where you are. So for example, in New York, I usually draft it as the grantor. When I'm doing my Connecticut revocable trust, I usually call that person the settlor. It's just sort of what's common in your jurisdictions, but they both mean the same thing. They are used as a will substitute. In addition to having provisions about what happens when you die, they also contain provisions about what happens while you're alive. So they are very thick documents generally. And because they contain so much about how you can handle your assets both while you're alive and while after you're deceased, that they really need to have much more information in it than a will would. They must be in writing, executed and acknowledged by the grantor. If there are trustees other than the grantor, then at least one trustee must also execute the revocable trust. So with a revocable trust, the grantor and the trustee can be the same person, because these are trusts that are just really that same person. We talked about this earlier. It's just John Doe with the word revocable trust on the end. It's using his social security number. It's really the one and the same. The key is that by executing it and transferring the assets to it or getting those beneficiary forms in place, we avoid probate. And that's really the crux of the revocable trust. The execution of the trust must be notarized or witnessed by two witnesses. I usually do both. I'd like to have belts and suspenders, and also depending on what you're doing. So, for example, if there's going to be a real property governed by this, then sometimes some jurisdictions require that the trust be executed with the same formalities the way a deed would be done. Other times they might say it has to be done the way a will might be done, depending on how this might be used in other jurisdictions. So in order to be safe, I figure I've got the people in my office anyway. I have a team of people that can be witnesses and notaries. So may as well, while I've got them, do both. And that way I know I'm covered regardless of what jurisdiction I'm in and what asset I've got. I know I've satisfied a witness requirement. I know I've satisfied a notary requirement, and I can call it a day. All trusts are irrevocable unless they are specified as revocable. So it is very important when you're drafting your revocable trust to make sure you make it clear that it is intended to be revocable and that it is something that can be amended and changed and revoked. You can have it be revoked or amended by the grantor. You can also have that using a power of attorney, that your agent under a power of attorney can make these changes. To me, that's a lot of power. And I get very nervous on that clause. I think there's pros and cons to that clause. I think there are definitely times when, life happens and life changes, and maybe my grantor has become incompetent due to dementia or Alzheimer's, something like that. And there's been a change in the family, and we do need to make a change to the documents. But now that person can't do it, using the power of attorney, depending on how it's drafted and depending on what the trust says, I can make that change and I can really do something good that needs to be done. The problem is that it also can be abused. So it can be used for good, it can be used for evil. So you really have to sort of see where you fall on that and whether or not you think in this particular family, what is the likelihood of it being used for either good or evil. So just be aware of the provision and don't just consider it boilerplate. Put a little thought into it and say what works for this family, and also check with your jurisdiction, because maybe a certain state might not allow you to use an agent under a power of attorney to amend the trust. So you do want to make sure that you think about this and don't just gloss over it and treat it like some of the boilerplate language that is in there. You need to give, if there's an amendment or a revocation, you need to give it to at least one trustee if there's a trustee other than the grantor. So very often our trustee is just the grantor, but there may become a point in time where maybe one of the spouses starts to have, the beginnings of Alzheimer's. So there's going to be a period of time where that person is fine and they can handle their assets, but we know what's coming down the road. So rather than wait until that person becomes incompetent and then replace the trustee, remove that person and add a new trustee, we start off on day one with two trustees, the husband and the wife, for example, in that situation. So in that case, we have more than one trustee. So it's really case determinative and it's based on whatever is going on. But more often than not, each spouse is the trustee of their own trust. But absolutely, there's no reason why it couldn't be the child with the parent. It couldn't be the spouse with the other spouse. It could be anybody. You just have to talk to your clients and see what makes sense. There is a way to amend an irrevocable trust. And the way I like to explain things to clients is that when we're doing irrevocable trusts, usually it's in connection with a completed gift or it's in connection with Medicaid planning, is the way to think about it is that once we do it, it's done. That is what is getting it out of your estate. That is what is making it a completed gift. That if you are not prepared to give this money away and to stop having control over it, then you should not be making this gift. That if I have a client who's very hesitant and says, well, what if I want to change it? What if I would have this? Then you're not really ready to be making this gift. And you should wait, you should push pause and come and talk to me next year about it. Because you need to be able to give it away and say, it's done, I gave it away. Now, there are things that happen and life sometimes happens and we do need to make changes. And we don't have a crystal ball to know what is going to be coming down the pipeline. So maybe, we do need to change something that happened in here. So there are ways to do it. We can amend an irrevocable trust or we can decant. Now, every state might not have these provisions, so you do want to see what your state allows. So when we decant, it is allowing the trustee to appoint the trust property in favor of another trust. So we're going to say, okay, we're going to take it out of Trust A and we're going to move all this stuff over to Trust B, which we're going to create now. It needs to benefit one or more of the current beneficiaries, and the remainder beneficiaries are one or more of the remainder beneficiaries of the first trust. So Trust B has got to have some kind of overlap with Trust A. In order to be able to do this, the trustee has to have the unlimited discretion to invade the principle of the trust. So if I have a trust that is very specific and just allows the trustee to invade for the ascertainable standard, for example, that is not unlimited discretion. That trustee has limited discretion to invade. It is only for those certain things. So we need to be able to, I see, okay. Sorry, there was something that appeared in the attendee chat, but it's all taken care of. Okay, if the trustee has, so we talked about the ascertainable standard, then there are certain restrictions and there are certain ways to decant, different kinds of ways to do it, that if the trustee only has the power to invade, for example, with ascertainable standard, then the trustee can appoint the trust property in favor of another trust that benefits the exact same current beneficiaries of the invaded trust, and the remainder beneficiaries are the same. So in our first example, we could, because we had unlimited discretion, we could pick and choose as long as there was at least one overlap. In our second example, our trustee pool has to match both current and remainder. The trustee can grant a discretionary power of appointment to one or more of the current beneficiaries of the invaded trust if the beneficiary could receive the principal outright. It can only exclude a permissible appointee in certain circumstances, and the trustee can grant any power of appointment to include in the invaded trust as long as the power had the same class of permissible appointees and is exercisable in the same manner. So, for example, if there was a power of appointment that said you could do it in your will only, when you do the new trust, you can't say will and a document during your lifetime or a revocable trust or something else. You have to keep it the same. So you have to really be looking and see and check the boxes. I like to do it like when I'm doing a decanting, I go through it item by item to figure out, okay, which category am I in? Am I in the first one with the unlimited discretion? So then I can do these things. If I'm in a certain discretion, then I can only do the others. And now the video is, I'm not seeing, oh, there I am. Okay, sorry, I thought my video had disappeared. All right, anyway, technology problems arise. If the trustee only has the power to invade the trust principal without unlimited discretion, so our example of the ascertainable standard, then the trustee can appoint the trust property in favor of another trust, which benefits the same beneficiaries. And the new trust has to include the same language with regard to distributing income and principal as the old trust. So we definitely have much less opportunities to make changes. But one thing we can do is we can extend the term of the new trust. So this is good for situations where the trust maybe ended at age, let's say 25. And now that we see what these kids grew up to be, we said, oh my God, this is awful. These kids are going to, be spendthrifts, they're going to gamble, and who knows what they're going to do. This trust needs to go for their lifetime or needs to go until age 50 or whatever it is. We can extend the time. If it is a class of persons, then the new trust must include the present and future members of the class. And if the invaded trust grants a power of appointment to a beneficiary, the new trust has to include that power of appointment with the same class of permissible appointees. Some key takeaways: new trust can have a longer term. We just talked about that. It can't be contrary to the intent of the grantor. And so that's also important, is that sometimes these issues come up because they realize that the trust that was actually created really did not align with what the grantor wanted when he created it, that somehow there was like a disconnect between what the attorney drafted and what the guy wanted. We have that situation going on right now with a client where they came to me with a trust, and when I explained what it said to them, because I didn't remember because it was drafted so long ago, they're like, but that's not what it's supposed to say. We were told it was going to say something else. I said, well, that's not what it says. They said, but we wanted to say this other thing. And the whole family said, oh, it was what we, all these years, that's what we thought it said. So that was a perfect situation where we needed to do something to change it, to make this trust say what for all these years everybody thought it said, because it didn't say. There was some disconnect when it got drafted. So there are certain circumstances where it may be really important to do. Decanting becomes effective 30 days after the instrument is served on the interested parties. Decanting does not need the consent of the grantor, interested parties, or court approval. So this can be a perfect thing to use when we have situations where we are worried about consent and we think we might have a problem getting consent. So maybe we want to decant in situations where we think there's going to be a consent problem. We cannot decant if it's going to reduce or modify a beneficiary's current right to mandatory distribution of income or principal, a right to withdraw a percentage or a specific dollar amount, if they've already started receiving that mandatory right. So it might say, once they turn 21, then they're entitled to the income. And at the time we're doing this decanting, that person is 25, so they've already been getting this mandatory income. But if they were 10, and they hadn't started yet getting the mandatory income, then we would be able to do it. It indemnifies against the trustee's liability, and it eliminates the provisions giving another person the right to remove or replace the trustee. If it fixes the value of the asset for distribution or allocation, and if it jeopardizes deductions or exclusions. So when we are doing this analysis, we want to consider first, and this is what I said before, I just want to reiterate it, do they have unlimited discretion or do they have limited discretion? And so if they don't have that unlimited discretion, then they can't do a new trust with new beneficiaries. And that, and sometimes we want to include new beneficiaries. Other times we just are going to have to decant to a new trust with different terms. Okay, we talked about the extending the term. Okay, we talked about this. Now, the other thing, and I like to use this much more often, is doing the amendment. If I'm not worried about consent, and I know that in this case, like for my example with the people that came to me and said, all these years we thought our trust said something, but it turned out it didn't. Everybody in the family was on the same page on that one. All the kids, all the grandkids, the surviving spouse, everybody was on the same page. So for that one, we just went with the amended route, and I had everybody sign off on it. And it was much easier than trying to figure out, was I in this situation and could I do these things? And was I in that situation and do these things? And this way I could just make it say what they wanted it to say and not have to worry about, did I have to stay in these specific rules and all those requirements with decanting? The downside was, though, that I needed everybody to sign off on this. So what we did on that one is we had some of the grandchildren who were still minors at the time. So we had the parent sign off for consent on behalf of the minor. And then we had a spreadsheet that had everybody's birthday on it. And once each one of those minors turned 18, we then sent the agreement out to them and we had them sign as well as individuals. So we figured this way, if something happened while they were still minors, at least we had the parents signing off on behalf of them. And this way, once they turned 18, we felt it was better to actually have that grandkid sign off and acknowledge on their own. And like I said, in this case, everybody was on board with these changes, so we weren't really worried that that kid wasn't going to sign. It was always just a question of just a waiting game for everybody to hit the right ages. All right, so now we want to update a will. So with a will, we need will formalities, as you all know, in order to make a will be a valid document. So it has to be written, it has to be witnessed, and the witnesses have to be at least 18 years of age and competent. They shouldn't be related to the testator. They shouldn't be named in the document. Same thing, by the way, on the revocable trust. If you're using the witnessing, same thing, 18 years old, shouldn't be named in the document, shouldn't be related. It typically would contain a statement saying that it is the testator's will and that all prior wills and codicils are revoked. That's usually right there on page 1. If the witness is also a beneficiary, then the bequest fails unless there are 2 other witnesses who are not beneficiaries. So if I have 3 witnesses, which is what we always used to do back in the Stone Age, now I always just do 2. It's a lot easier and people don't have to leave their desk and stop working in order to be a witness. But if I had 3 witnesses and one of them happened to be inheriting, then it would be okay because I still have 2 others. And so that's one thing, like, we often joke around with clients, and some clients are wise guys and they'll joke and they're like, oh yeah, this document says you get everything, right? And I said, well, I don't, because I'm acting as one of the witnesses. Or if I'm playing notary, I say, well, maybe because I'm just the notary, so maybe it does say everything to me. Depends on the relationship you have with the client. But that is always a good way to reassure clients, especially if they really are confused about the actual meat and potatoes of the documents, the actual words of it, rather than maybe a summary you gave them or a letter explaining it to them. You can reassure them that, look, if I'm witnessing it, I can't be inheriting. So that always gives people a lot of peace of mind. If the witness is a distributee, then that person can claim his intestate share as long as the share is less than the bequest under the will. And the execution for a codicil, which is the way we change a will, is the same as doing it for will. We need 2 witnesses, we need the notary, self-proving affidavit. All of that is the same for a codicil as it is for a will. In this day and age where everything's on the computer, what I tell my clients is it's much easier to just do a new will. You want to change your trustee, you want to change your executor, I can have my assistant change a name. She hits print, poof, we got a new will, we're done. It takes 5 seconds. You want to change, the trust and change the age in it, no problem. We go into it, save it as a new document, change the age, hit print, poof, we're done. It's probably even faster for me to do a new will than a codicil, to tell you the truth, because for the codicil, I still have to change the stuff, cut and paste, and put it into a new form and whatever. This is literally pulling up the old document, saving it as a new one, and changing a couple of things. If I do it as a codicil, then when the person dies, I file the codicil and the will with the court. Anyone who was adversely affected by this codicil is now somebody who can object to the will and the codicil. And that is another reason why doing a codicil, and this is actually the main reason why a codicil should not be done. So I have created a potential situation where I don't need to. If I just do a new will, then this person who got left out of the new version of it, or who used to be an executor and now isn't, and who used to be a trustee and now isn't, or used to be the guardian and now isn't, whatever it was, they used to get $5,000 and now they don't. They can't object to anything because they don't know that they got screwed by the new document, excuse my language. And therefore, I don't have a potential will contest on my hands. If I have to file the codicil with a will, then they know they were in it and now they're out of it. And therefore, I now have a potential will contest on my hands. So it's just, and since it's all on the computer and it doesn't have, it used to have to be retyped. When I first started practicing, there was carbon paper and you used to have to type things, and now everything's on the computer. So it's just much easier to just do it as a brand new will. And clients, and though they don't really understand, and for them, they think, oh, they're going to get charged more because it's a new will. And so you as the attorney have to do a little bit more reassuring to explain to them why doing a new will is actually not going to cost them more than doing a codicil, and why it's better, and how it avoids the will contest, and all the reasons why, if they go the will route, why that's easier. So when we want to update the estate plan, and when we're deciding whether or not we need to amend a trust or do a new will, we want to send clients legal alerts periodically. We want to send them interesting articles. Maybe reach out annually on their birthday or with holiday cards. Maybe in a perfect world, send them a letter telling them to review the checklist annually, request information about life cycle effects, events. Did someone die? Did they have a new baby? Did they move? New job, retire, assets, go up, go down? Is anyone sick? Things like that. You also want to encourage clients to dust off their documents, not just the wills and not just the revocable trust, but also take a look at your healthcare forms, take a look at your powers of attorney, give everything a well baby checkup and make sure it's okay. I usually tell clients to do it around tax season because they're thinking about their assets at that time anyway. So at the same time, you're doing all your tax stuff for the accountant, take out your stuff, take a look. Does it all make sense? It does? Great, stick it back in the drawer. Something doesn't make sense, something's different, shoot me an email and say, do I need to change it because this happened? I'm getting a lot of questions these days about, do I need to change my documents because of the big, beautiful bill that's happening in Washington? I said, until the big, beautiful bill actually passes and it moves from being a bill to actually being a law, then we'll worry about it. But for right now, there's a lot of question marks out there. So let's not rush to do something until we know what's going on, or until we get closer to year end. It's still a little too early to start wholesale changing of plans when we have too much uncertainty. If you stay in contact with the client's accountant or the broker, their banker, the financial advisor, you're going to know what's going on, that maybe something happened. Maybe they moved. Maybe there's a new baby. Maybe somebody died. Maybe somebody got sick, because they might be talking with their financial advisors a lot more than they're talking to you. And therefore, if you've got a pipeline with the financial advisor might say, hey, did you know such and such happened? Oh, no, I didn't. Well, can you tell them to give me a call about that? Or you can reach out to them and say, hey, I just spoke with your financial advisor and they mentioned this to me, so I think we should have a conversation. Also, if you're the family lawyer, then you also will know what's going on. So if you can represent multiple generations and multiple branches of a family tree, then you also know what's going on. And it's a good way to make sure that you know whether or not it's time for them to be updating something. Because, if you were at the kid's wedding because you're in touch with the family and you know everyone, then well, maybe it's time to have that kid that just got married no longer needs a guardian in their will, and maybe would be appropriate to be the executor instead of Uncle Bob, who wasn't able to come to the wedding because he's sick and living in an assisted living facility at this point, or in a nursing home or something like that. Because you're in touch and you know what's going on, you're able to say these things need to be changed. And so all of the bequests, all the things you want to do, whether it's specific bequests or percentage bequests or things that come before the residuary, things that come after the residuary, you can do either one with the revocable trust or the will. A lot of times people think that the revocable trusts have to do with tax saving and that they're really tax savings devices. I just had this conversation with someone yesterday, and I was explaining, because their accountant said that they should be doing it. I said, you don't need to be doing this. It's not going to change anything with tax savings. I said, any tax savings that's built into the plan with like disclaimer trust, things like that, that's in a will or the trust. It's really just about probate avoidance. And if you're not going to have a distributee problem and with distributees, for example, in New York, when you probate a will, the people that are named in your document have to be given notice or sign waivers, depending on what category they fall into. And anyone who would inherit, if there was no will, also has to be given a waiver and consent to the will. So this is where we run into headaches, is that if your distributees are distant relatives who you've never even spoken to, and now they're going to have to sign a waiver, this might be a problem. We see this a lot with people who are single. We see it with people who are maybe Holocaust survivors and don't have family and don't really know much about their family tree and when people died or where they died, because we have to give information about the family tree when there's only one distributee. So in situations where we know it's going to be a problem, or we know we're going to have a distributee issue, let's avoid the whole thing. Let's do the revocable trust. And then we don't have to worry about a probate problem. Some jurisdictions, probate takes a really long time. So certain counties in New York are notorious for taking a really long time to probate. If you live in one of those counties and you come to me for your estate plan, I will tell you, we're not doing a will. We're not going to deal with the court in that county. We're instead going to do a revocable trust and avoid the court entirely. If you have property in multiple jurisdictions, we want to do a revocable trust because we want to avoid having to probate in multiple jurisdictions. My client with the house in Vermont, I don't want to have to go to Vermont and probate there. What if they have a house, overseas? I have a lot of clients who have homes in Israel, and I don't want to have to be dealing with foreign courts. So it's very important to know what they have and what their situation is in order to know, is this ripe for doing a revocable trust? Or is probate fine? So if they're not relying on the money and it's not going to cause a problem, that if they don't inherit and they don't have that money the very next day after the person died, because maybe there's enough assets in that survivor's name, or there was enough passing jointly by some beneficiary form, then if we have to probate and it takes a couple of weeks, or even if it takes 2 months, the world won't end and the probate fees aren't so high that we can probate and we can just stick with a will. So it really just depends. People don't always have the stomach for doing the funding of the revocable trust. It's really key. If we're going to avoid probate, we got to fund those revocable trusts. And that's where we run into problems. So if they're not going to really be on board with that, then we can't do it. It looks like we have a question that came in. All right, so in our last minute, I have a client who wants to modify an irrevocable trust. All beneficiaries and trustors want to make the changes and would sign off. The changes are necessary because of a death in the family of one of the children and his divorce from his spouse. The changes would create a trust for minor grandchildren and keep the assets away from the divorced spouse. The grantor has tax problems and owes money to the IRS, which he is planning to settle with an offer and compromise. The trust has existed in its current state for 39 years. The trust grantor is worried that making the revisions will make the trust penetrable by the IRS. Over the 40-year life of the trust, it has been funded with appreciating assets the grantor does not want his estate or reachable by the IRS. Can you offer any ideas on how to do this? If your state allows the amending of the trust, like New York does, for example, I don't see why it's allowed by statute. The grantor is not gaining control of these assets. So in theory, it shouldn't create a problem with the IRS. You have to see what's allowed in your state. So I don't know what state you're in, but if you're in New York, in theory, you could just amend that trust. Now, we can certainly talk offline about it and get me some more details. So I'm happy if you want to reach out, tomorrow or next week, we can talk some more about it. So just give me a call or shoot me an email. My information's in the materials. I'm going to turn you over to your next speaker because it's 3:15. I want to keep you on time. And thank you so much for letting me talk to you about my topic as well as the topics of my colleagues. And have a good weekend, everyone.